Well, it is noon, so we'll get going. Hi, everybody. I'm Kristen Watson. I am the investigator for Iowa City Human Rights, and this program is part of our Lens series. We'd like to welcome Mark Kende, who is a professor at Drake Law School, and he will be presenting on recent cases from the Supreme Court, which may or may not have killed affirmative action. Also, we have applied for CLE credit for this program. So if anyone who is in attendance is an attorney, the activity number for this program is 402-388, and it is worth 1 hour of CLE credit. So take it away, Mark.
Well, first, thank you very much for the opportunity to give this presentation and also hopefully get some input back from folks and questions regarding what I talk about. So I'll talk for a while, but try to leave some time for questions at the end as we discussed. But thank you for your work organizing this as well. So I tried to ask a provocative question to sort of get us started, which is affirmative action dead? Deliberately being provocative. That's sometimes what professors do to try and get interest in things. And the short answer, I think, is no. And I'm going to try to explain why, although I also believe that this is an area where obviously affirmative action is not going to be the same as it was before. And in that sense, if you want to call it dead, you can. But I do believe there are methods, and even the Supreme Court has indicated there are ways to try to go about making sure that disadvantaged individuals are enabled to participate and go to law school. If the law schools or the universities, for example, do the recruiting and do their admissions in the right way. So I'm not ready to say it's dead yet, although it's complicated and it's problematic, and I wish the Supreme Court had not decided the SFFA case the way they did. Although I do want to mention one thing. This has always been a kind of precarious area. If you go back to the Bakke decision, which initially said you can have affirmative action, Bakke was really just one justice, Justice Powell, who introduced the idea that diversity and no quotas, focusing on racial diversity without quotas would be something a university using its First Amendment prerogatives would be able to do if it did things such as, and it presumably would, and would be based on creating the likelihood of less racial and cultural stereotypes, if it would create more cross-racial understanding, make for more vibrant discussions in the classroom, etc. But this was precarious from the start. There were 4 justices on one side of him and 4 on the other. His diversity opinion kind of became the law, as you know, in many schools, most schools, in fact, and it required holistic examination of each candidate in order to be valid. Race could only be one factor. You could take account of legacy, athletic prowess, whether someone was a great violinist, etc. So it's always been a little bit precarious. Candidly, my own preference is that I wish he had gone with the argument that affirmative action is justified based on a remedial logic, that the way we treated blacks and made people slaves and then had Jim Crow and lynchings and just the horrible history of mainly whites, obviously, mistreating blacks, and then that has extended to other racial minorities as well. That kind of remedial argument, I think, would have been more powerful, although he said it was too broad an argument. We couldn't measure that. And ironically, there's a little bit of a link, because if you read, again, Chief Justice Roberts' main opinion in SFFA, he says the problem is you can't measure diversity. So I want to discuss that opinion, discuss what ramifications it has for universities in other areas of how universities function, and discuss some of its ramifications for corporations. My background, just so you know, I was a civil rights lawyer for about, half a dozen years or so, close to that, in Chicago. I worked with EEOC folks there. I worked with people at the Illinois Human Rights Commission there, which might be somewhat analogous, although a little bit larger, obviously. And then I'm also now a constitutional law professor. So you're going to get a little bit of constitutional law mixed in with a little bit of some of the more statutory civil rights issue. But let's start with the big constitutional law case, SFFA. And as I mentioned a moment ago, Chief Justice Roberts, and he's not the first one to say this, other justices on the court have always viewed the justification of diversity as too amorphous and imprecise to be a satisfactory, compelling state interest that is also something that the university is using that's narrowly tailored to promote that interest. They've always seen this as too mushy. In earlier affirmative action cases where affirmative action was upheld, the universities often referred to the need for a critical mass, and they raised what I think are serious issues about, well, what is a critical mass exactly of racial minorities? And, you know, isn't it the fact that in some situations where you have affirmative action justified, it's really not the case that you have a critical mass? So they raised those issues. I think there were very good responses on the other side. I'm not going to emphasize those right now because I want to cope with this potentially devastating decision, although, as I said earlier, not, I don't think, deadly, but certainly very, very difficult, complex decision that we have. So what did he say was unmeasurable about diversity as a justification? Well, he said actually diversity is, you know, something that, how do you determine whether you've got sufficient cross-cultural understanding going on in the classroom such that it can be justified? How do you put a number on that? How do you measure that? Cross-racial understanding. What does that mean exactly? He argues. He also argues this is going to create more stereotypes, which of course is a standard anti-affirmative action argument, because it will be assumed that some of the minority students could not have gotten any but for diversity and therefore don't have adequate qualifications, which I think is an incredibly narrow-minded and inappropriate view of how admissions work and how they should work. And this is sort of interesting. He argued there's no logical endpoint. And some of you may know about 25, well, not 25, but about 20 years ago, Justice O'Connor said in an opinion upholding affirmative action, you know, maybe this should last another 25 years because now, she said in 2003, we're already 25 years in, but we still have a lot of work to do. Interestingly, Justice Kavanaugh in concurrence really focused on the 25-year period. Chief Justice Roberts didn't quite focus as much on that, but did show concern about there's no logical endpoint here. And, you know, that's not a irrelevant argument when it comes to if the court is going to use strict scrutiny, which is another thing I would have disputed. I'm not sure they should have ever used strict scrutiny. Brennan and some other people on the court said this is not like normal racial discrimination. You should therefore use intermediate scrutiny. But under strict scrutiny, you do use this more difficult test. So that's kind of a very short summary of what SFFA said. Let me talk a little bit, though, about how it has blown up. The people behind the challenge, the SFFA folks, led by Mr. Blum and some others, aren't going to stop there. And we know that just immediately because within a very short time, they sued the military academies, which was, of course, something interesting because in the case, Roberts had a footnote where he said, nothing we are arguing about what's wrong with affirmative action in universities applies to the military academies because they know what's kind of in the best interest of national security. And that was almost an invitation, a sort of backdoor invitation. So there are now lawsuits pending against the military academies that do use some forms of diversity focus in terms of their recruiting. I can tell you there's some very interesting cases that don't get much attention from lower courts during periods when there was urban unrest in the 70s, et cetera, where one of the arguments for affirmative action was the need to have more minorities in the police forces so they could relate better to the communities and thus make riots and other things less likely. Well, that's a little bit like the military academies arguing we need a diverse military made up of all sorts of Americans to represent the country, but to also, again, be more effective. So, but that, what I call operational needs argument about police forces never got traction and has not been accepted. And so, the argument that the Blum folks are making is the justifications the academies are using are just not adequate. So that's one area they've already just immediately jumped into. In a way, I don't want to draw too much of an analogy or divert our attention too much, but it's kind of like what happened with the abortion decision that reversed Roe versus Wade. As soon as the court overturned Roe versus Wade, states were putting into effect new laws restricting abortion. Other states had trigger laws that were going to go into effect immediately. Another thing that happened, as you may know, is Republican attorney generals from 12 states at least sent letters threatening, not threatening in a violent sense, but threatening legal action if corporations, major corporations, did not take actions to tone down their diversity efforts. So this is a broad extension, very broad extension of SFFA. From our perspective, or from my perspective to be more accurate, the problem with SFFA, besides being wrong, is that it has opened the door to this Pandora's box of lawsuits occurring. And we don't know how far that door is something the Supreme Court is going to want to run and sort of go forward through in terms of dismantling diversity programs, not just diversity admissions in universities, but diversity programs. Now, as you know, diversity programs of different types, many types, or DIE programs, as they're sometimes called. Actually, at Drake, we now just call them IE programs because we have taken the word diversity out in order to try and make it less likely that we'll be sued, but still trying to accomplish most of the same things. We've made a few other adjustments at Drake as well. So, this is the situation we face. And most of the rest of what I want to discuss is what's going to happen potentially. And this is a little bit of crystal ball work. So please take what I say with a grain of salt. And I certainly don't know exactly what is going to happen, but things are definitely going to be a little more difficult. But I also started by saying diversity action is not dead. And let's go with the Biden administration, for example. In response to the Republican attorney generals, the Biden administration has issued directives, their education department has issued directives that in quite a bit of detail have described things that universities mainly, it's from the education department, can do to still try to ensure that they get, a relatively broad diversity. Broad meaning not just racial minorities, because that's the lesson. If you were to say, what is the fundamental basic ruling of SFFA? It seems to be you cannot use race in admissions as a deciding or quasi-deciding factor. And the problem, though, is, as I said, that argument or that view has been challenged as people have gone forward trying to do more with it. But the Biden administration has said, first of all, we should interpret this case narrowly, thus disagreeing with the Republican attorney generals. And secondly, it has explicitly offered opportunities and options for going forward with forms of activity which, while not quite like diversity under Bakke, nonetheless are likely to result in opportunities that give people who are disadvantaged, including racial minorities, but also including disadvantaged white people, chances. Now, they did not draw this from nowhere. Chief Justice Roberts, at the end of his opinion, says, essentially, it is okay for a university to take and look at the characteristics of people who it is considering for admission and look at factors regarding their character as part of their recruiting. They can look at factors like courage. They can look at factors like obstacles that have been overcome. And one of those obstacles that have been overcome, and an example of courage, he basically says could include references to racial minorities who could write essays to these colleges explaining that because of their race, they have had to overcome these particular obstacles and these particular characteristics. The idea, though, is they can't say, and I'm going to simplify this, you should give me a leg up because I'm Black or I'm Latino. They have to say, you should give me a leg up because I've shown courage, I've demonstrated character, and I've done that by overcoming some obstacles that may have to do with my race. So that's the fundamental reason I think affirmative action can't be described as dead. I think that does open the door to people making these arguments. Now, I have no doubt the other side, SFFA, and the Blum folks are going to watch like hawks to see that this is not a method used to circumvent the ruling in the case. In fact, no less distinguished a scholar than Erwin Chemerinsky, who some of you may have heard of, has already been criticized as supposedly advocating ways of circumventing SFFA at a conference. I don't think that's true, and I know Irving, and I think he probably spoke with a lot more diplomacy and nuance than that. But I also assume he probably does have some concerns and would like to and make sure that diversity continues. And in fact, he has said that. But my point here is that that language from the opinion does still leave opportunities for universities to promote diversity. Now, there is no doubt, though, that in some ways the case has negative other factors. For example, there have already been litigation filed after SFFA regarding the issue of scholarships designed specifically for minority students. And we have a scholarship program at Drake that we have to re-examine to decide whether we can do it. But lawsuits have been filed in that regard. But again, that raises the question of, if you open the scholarship up to disadvantaged whites, can you nonetheless therefore say it's no longer race specific, and therefore it's a permissible form of diversity? The concern about that opening up is that states like California, Texas, and Michigan have banned affirmative action per se based on race. And some of you may know for years, particularly California and Texas, really struggled to restore the numbers they used to have in terms of numbers of racial minorities at their law schools, at their university. The law school numbers, the first year or two after some of these decisions by the states, were awful, numbers like 3 students per class. But as time has evolved, they've made some very strong efforts, and those numbers have gotten much better. And we do have a map, not just from the Biden administration, but from those states as to try to how to do this as best we can, given the problem of this case. So again, I'm trying to be a bit of an optimist, even though, of course, I can't ignore my pessimism about this particular court. And if some of these cases reach the court, it might have an inclination to see circumvention going on, when in fact, actually, it's just compliance with that last part of the Roberts opinion. Another issue that comes up is diversity training and what you might call DEI groups and DEI training. And this occurs at both the university level and it occurs in corporations. And to some extent, you're talking about 2 different things here. corporations are not typically governed by Title VI, which was the law that affected Harvard, but that's also using a constitutional standard, which means it's following the case. Corporations are fundamentally supposed to follow Title VII, and Title VII actually bars race discrimination at all. So in some ways, corporations could say, if they didn't have the diversity programs, and if they were trying to make sure they didn't discriminate in hiring and promotions, they don't have to change anything. But corporations have definitely jumped into this area for good reasons. We have a global business world. We have a community in a United States that is changing. And to ignore the markets that are there, to ignore the importance of these markets and the need to have salespeople who can candidly be parts of these communities is vital. So let's start with universities in terms of what this case means. One, again, narrow interpretation is it doesn't change anything other than admissions. But universities are adjusting, as I already mentioned, Drake is adjusting. One thing, the Biden administration letter, I believe it's their letter, I'm not sure, I can't remember, I've looked at a number of sources and I've read a lot of advice that law firms are giving their clients. But it does not seem there's any rule against what they're calling now affinity groups. Now, you could just call it a, kind of group other than an affinity group, but there's nothing that would prevent and does prevent, and we have this now at our law school, an affinity group being established that is open, though, not just to racial minorities or not just to women, but also to white men, and including not just white men who are disadvantaged, but if someone is, coming from an advantaged family, but nonetheless is committed to this cause, wants to be a part of this community in some way, we have to open that up, it seems. But I'm not so sure that's a terrible thing. It's not what I would want, because I think the target audience should be the groups that have been historically disadvantaged. But our affinity group is quite active. There has been a backlash to this case that has created some activism. There's been an even bigger backlash in the abortion case, by the way, as you see from vote after vote from the states upholding a right to abortion. But there's been some backlash here, and maybe people with this backlash will become more active in this area. Again, I'm trying to paint or look at some of the optimistic possibilities. Now, corporations are more complicated. If you read Justice Gorsuch, who wrote a concurrence in this decision, he links in a somewhat ominous way the Title VI analysis that was done in the case to Title VII. Why do I say it's ominous? Well, if Title VI standards apply to corporations, then you're kind of saying corporations are subjected to this case. And that's not correct, and it's problematic. Having said that, though, it would be unreasonable to not admit corporations are usually somewhat cautious. So one effect of this case, even if you don't buy the Gorsuch argument, is it does and is a case that has had a chilling effect on diversity programs at corporations. A few of them have actually abolished these programs or the training options. I think the smarter corporations have not done that. They've simply tried to open these programs up more in a way where there's not as much focus on just race. And they've tried to make them in a way, I don't want to say less mandatory, but let me give you an example of what would be a bad thing. It would be a bad thing now after this case, and it is probably something that does still go on, for companies that have these programs to make everyone in the program sign documents swearing to follow the corporation's progressive attitude on this issue, or allegedly progressive, because sometimes one suspects corporations do that for marketing reasons, not just for noble reasons, but to assuming they're doing it for noble reasons, some corporations require people to do the training and then sign documents that they agree with everything. Some make that an entry requirement. I think those would be problematic, not just because of this case, but those would be problematic under what is called in First Amendment law, the compelled speech doctrine. So they were actually problematic anyway. In fact, one of the most interesting things I read in this area was the following statement by someone connected to the EEOC who said, actually, corporations have been doing too much in the diversity area for a long time, since Title VII prohibits basically race discrimination. Now, you can disagree with that statement, and I want corporations to do more, probably maybe as some of you do. But it was an interesting argument that, maybe in some ways this reins some of the better programs in. Now, the thing I find depressing about that, though, is I want corporations to be able to celebrate the fact that they are promoting diversity. This is just too important for our country, given our history. And so this is also, like I mentioned, having a chilling effect. So some corporations are maintaining their programs, but opening up the programs a bit. And like I said, so that whites can enroll, but then diminishing any advertising or publicity about these programs as a way to not be a target. Whereas before, these would be celebrated as, come to our company to work because we are a diverse workforce. That's a terribly unfortunate consequence of this case. So that doesn't mean, though, the following. It does not mean this case bans training with regard to cross-cultural understanding or cross-racial understanding or stereotypes. Does not mean you can't have programs that talk about the value of those things. This is my view anyway. And to read this case that way, which is how it's being read by many conservatives, and these attorney generals, they didn't write the corporations by accident. That's how they interpret it. I think that's a huge stretch. And I also think corporations with enough tweaks can still continue with some of these programs. Although, as I said, some will back away, maybe those who are not as truly wanting and being dedicated to this issue. So that's a little bit of a summary of, I think, what's happening with regard to diversity programs, diversity training in corporations. I will say there is an onslaught. There is a bunch of lawsuits, and not just from, Blum's group, that are being filed. There's a white student at NYU Law School who's suing their law journal on the grounds that the law journal has a kind of affirmative action plan. That's actually a pretty strong lawsuit, if I can be candid. But it's just an example of how this is, stretching out into areas. But the diversity training and diversity program area is not dead. University admissions, though, is clearly got to make adjustments. Some schools, very prominent Ivy League schools, no longer require diversity statements from people who are applying to teach because they don't want to be accused of violating this particular ruling. But there is one bottom line to this, which is we just don't know what this ruling means completely until we get further rulings. It's a scary start. It does not, though, in my view, eliminate the possibility of actions that promote diversity. But the reality is much of what I'm saying is speculation and a bit of information about what's going on the ground. And some of what I'm saying is based on, like I said, uncertainty about what the court will do in this particular area. Let me mention one case that is pending before the U.S. Supreme Court as well that I think everyone should know about, and maybe you do. There is a case called Muldow, M-U-L-D-O-W, pending before the Supreme Court. The issue in Muldow is whether Title VII allows someone to bring a lawsuit without really being able to show that the discrimination they claim they suffered was powerful enough to amount to an adverse action. So let me say that again. It would allow someone to bring a lawsuit claiming they've been discriminated against, even if the nature of the discrimination might be viewed by the court as typically not sufficient to constitute an adverse action. What's an adverse action? Well, if someone's fired, if someone's not promoted, if someone's harassed, well, if that's for discriminatory reasons, those would be affirmative actions. This case involves a job transfer. And so there's an argument being made by the defendants that we just transferred this person from one place to another. Whether or not we did so for racial reasons, and of course, I assume they're arguing they didn't, but whether or not we did, it's still not covered by Title VII because it's not an adverse action. This is a scary case because if the court were to rule that that requirement of an adverse action can be met very leniently, it means that people who are offended by diversity programs, who feel like the diversity programs give a leg up, the ones that still exist even after this case, even if they cannot show a concrete injury, might be able to invoke Muldow to say that they're suffering in some way. They're suffering some type of injury. Now, what's ironic about this is I used to be a plaintiff's lawyer in the employment discrimination area. And in the old days, when there was no problem with Bakke, this would be a great decision for plaintiff's lawyers, because then you could bring a lawsuit on behalf of a racial minority and not have to show that the adverse action was perfectly clear. But given the post-SFFA world, we see people now on the side challenging affirmative action, and if they don't have to show a more concrete injury, that's bad news. So it's kind of ironic that, now I'm against it, but maybe 20 years ago, I would have been thinking, wow, this is a great opportunity for plaintiffs who are being discriminated against to stop the discrimination, even if the adverse action is a little bit ambiguous. So that's kind of a strange position for me to be in terms of, like I said, I would have viewed this completely differently 20 years ago. I also want to talk about one other case, which is another reason why I say, let's not get too pessimistic here. The U.S. Court of Appeals for the Fifth Circuit recently ruled that NASDAQ, so NASDAQ obviously is sort of a more tech-oriented version of the stock market. NASDAQ has a requirement that companies in NASDAQ, and some of you may know about this, it's a case called Hamilton from the U.S. Court of Appeals for the Fifth Circuit, which, by the way, is a conservative court. So it's a bit of a surprise. NASDAQ requires that most companies there, or maybe all, I believe, must have at least one woman on their board of directors and must have at least one person who fits into the category of a minority, a vulnerable minority, transgender person, an African-American person, etc. What's incredible about this to me, and candidly, I'm just learning a little bit about this NASDAQ rule, is those sound like quotas. And they even sound like quotas in a way that would be contrary to Bakke. But you see, here's the difference. NASDAQ is not a government entity. So you could argue technically Bakke doesn't apply, and it's not an entity that Title VI applies to. And the US Supreme Court, despite this diversity ruling we've been talking about this whole time that's so bad in terms of affirmative action, the U.S. Court of Appeals for the Fifth Circuit upheld the NASDAQ rule, and it was a conservative panel, or not a conservative panel. That's not accurate, I should say. It was a liberal panel. I actually have gotten that wrong. So, whether that will stick or not, we'll see. It just so happened when the case came up, the three judges who are drawn randomly were judges who are, quote, liberal judges in the sense of Democratic appointees. So whether that will last or not, it does suggest that there are people out there who do not believe that what happened within, recent years means the end of any opportunity to help women, racial minorities, other vulnerable groups, etc. So to sort of summarize, this is a terrible case, no doubt, for proponents of affirmative action, but I don't believe it's the death of affirmative action. I believe creative advocates who wish to take measures can do so, and can do so in ways that don't violate this case and that don't violate Title VII. It will probably cause some downturns at certain places. It requires, to discuss what I mentioned earlier, it requires more courage of corporations and universities. And Chief Justice Roberts, as I mentioned earlier, seemed to value courage in students. So this is going to require more courage in terms of these entities. The big question with my somewhat optimistic view is what's going to happen next, because we know this is a conservative court. These cases that are now percolating all over, some of them will get to this court. And if the court takes this SFF case as only the first of a whole bunch of cases that it's going to use to wipe out, to really try to wipe out diversity efforts, then that would be the worst case scenario. But I'm certainly not myself at the point where I'm willing to concede that they will do that. So I want to thank you for your time. I want to thank you for your patience and listening to me ramble on. And I would love to answer any questions or thoughts that you might have. Thank you.
Questions from anyone? You can either type into the question or chat box or just raise your hand.
I'd be interested in hearing from people, even if they don't want to ask questions, about what it's like for you all on the front lines in this slightly new world. Maybe it hasn't changed a lot. I don't know, but I'd be interested from hearing from individuals who, work in this field or in this area. If people feel like sharing, if they don't, that's fine. So.
It looks like somebody has their hand up. Go ahead, Adrienne. You can unmute yourself. Well, Adrienne had her hand up, and you should be able to unmute yourself.
Can we as hosts unmute them or no?
I am trying. I don't see a way. I gave Adrienne permission to talk. But I think she has to click unmute her on her own. And while we're trying to fix that with Adrienne, we have a couple of open questions. Jordan says, do you anticipate that private scholarship sponsors who offer scholarship programs for LGBTQ students, for example, will have to or choose to roll back those opportunities?
It depends in part, I think, a little bit on whether the donations are going to public or private universities in the first place. I think public universities are even more clearly in trouble in this regard, unfortunately, than private universities, but the standards are similar. So I do believe there are potential problems, yes. I think if the scholarships can be made in some way to be a bit more flexible, which is obviously not easy. If you really want to help an LGBTQ student, why would you make it more flexible? But there may be other ways of getting money to these students that don't formally involve just an LGBTQ scholarship, but maybe a broader scholarship fund, if you will. And so I think basically the answer is yes. I think there are some problems, but I'm not of the view that it's impossible to figure out some ways to still make such money available. It just might have to be done in a different manner. And I'm not trying to circumvent this case. You know, with money, people do all sorts of creative things. Why shouldn't they be able to do creative things with money if they want to help someone who's an LGBTQT student? So.
And then Jay asks, I picked up equity and courage as new approaches. Can you talk more about how to exercise these things in college and corporate and public service realms?
Great question. I mean, in terms of college, it's fairly straightforward because Robert says that basically the admission essay is where the student can address this. So the smart universities and colleges probably are, in fact, I know they are, debating and discussing how to alter the older essays. They're removing the box that used to exist in some places where you would just check your race. That box is getting removed. But, you know, if the essay is available, you can certainly write about that. I think corporations are similar in the sense of, you know, when you're hiring, you want to hire people who have character. And so, again, if they can come up with a method that allows people to present themselves and the courageous or other obstacles that they overcame, which might include racism or bias against being an LGBTQ person, I think corporations can also take those things into account. Now, corporations are subject to Title VII, so they actually cannot favor race at all, really, if we're going to be technical about that. But again, the argument would be you're not favoring race, you're favoring courage or character. I just want to mention, though, of course, the people on the Blum side of things are going to challenge these attempts, as they're going to say efforts to circumvent the ruling. But I just don't think that's accurate. And if it's done right and smart by corporations and universities, I think they should be able to get this information. I think that language by Roberts is no accident. And so, you know, there are ways that this can be done. The main way is to highlight those factors. These, whatever they come up with in terms of their new admissions essays or whatever corporations uses their new applications, encourage the new people who are applying or people who seek promotion to point out these particular things, examples of courage, examples of character, so that there's just no doubt that this is something the university or the corporation wants to hear about. Advertise this as something they want to hear about, and make it very explicit so people, there's no way people can miss it. And then I think it can be a way to try and make some progress despite this decision.
And we have someone anonymous asking, where can we get help to review our policies if we work for university programs that support underrepresented students? We don't know what we can or cannot say anymore in terms of our eligibility criteria and recruitment materials.
Well, I would say there's a number of sources that you can look at in terms of universities. The Department of Education under Biden has issued a long question and answer document that specifically kind of addresses what you're asking. So make sure to access, maybe you've already done that anyway, because it could still be longer. I wouldn't have minded even more detail. Along with that document, they've issued some directives related to this. There are on-the-ground advocacy organizations. I couldn't understand last night when I was working on this. There's one called Democracy, and it's called either Democracy Forward or Democracy Core. I couldn't really, because of the internet, pick up which one it is. They list almost every lawsuit that is now pending. So you can get a sense there as to, you know, some do's and don'ts. But I think as a general principle, and this is what we're trying to do at Drake, is the more you can indicate that these kinds of trainings and programs are not simply designed to help racially disadvantaged people who come from groups that have historically been disadvantaged based on their race, but also people who grew up poor and maybe white. You know, you're not barred from saying your program helps people based on race, as long as now it seems you also have to make your program be something that helps other people, white people, for example, who are poor, or even white people who aren't poor. Does that create a risk that the program won't be quite as effective, or maybe that the bonding that you want to establish could occur? Yes, but like I mentioned, we've established an affinity group here. It's open to pretty much anyone, but it's obvious to people that it's mainly designed to help racial minorities and others to be able to fit in. People are smart enough to know what's going on. So even if you open it up to white people, and you may get some, and that's fine, I still think those groups will function in large part to help racial minorities. But it's a matter of sort of dancing around this case. And I'm not saying circumventing this case, because, this case specifically says you can do this, basically, I think. And, but I'm not saying it's easy. It's now become much harder. It's much harder to say, well, let's just have racial minorities bond, of certain groups, et cetera. That becomes much harder, and you have to be more cautious. But I think there are ways to do it. And other sources, I mean, the, various academic clearinghouses, or the various bodies that survey colleges and universities, the Chronicle of Higher Education, Inside Higher Education, all of those particular websites are obsessed with this issue. So, you go to those sites and you find out what people are doing, or you find out where people are trying to figure out what to do, and you make contact with them and you collaborate. And so if we work together as people who care about this, I think we can make progress. My fear is, though, that this is only the first step. But at least at this point, that's all it is. It's just the first step. So that seems to leave lots of open room, but we have to be creative.
And Jeff says, I was shocked after reading some of the conservative justices' opinions by how narrow-minded their arguments were, and how the narrow-mindedness was not directly addressed by the liberal justices. They all seemed to willingly lock themselves in the box of strict scrutiny. Ms. Jackson's opinion argued sociologically without directly acknowledging this difference in argument. Why are these people so circumspect?
Great question. So, unfortunately, strict scrutiny is just not going to change. And, that's been okay so far, because even with strict scrutiny, these plans have survived. And the most recent case before this one was a case involving the University of Texas. It always seems we come back to Texas somehow in these cases. And they had a unique affirmative action plan. And the court said it was going to really use the second Texas case called Fisher 2. Fisher 2, the court said, we're going to really be strict here. And then they still said the program was okay. So in a way, they didn't need intermediate scrutiny, and there was no chance they were going to get it, because those other justices, as you point out, are incredibly conservative and, I believe, narrow-minded on this particular issue. As I said, and I'll say this again, one of the tragedies of affirmative action is that it does have some strict scrutiny involved. As someone who teaches constitutional law, we say that you use strict scrutiny to prohibit laws that are based on bad motivations or are doing bad things. Affirmative action, whether you like it or not, is clearly based, I think, on a motivation of trying to help a group or groups that were historically disadvantaged. So from the moment Bakke was decided with strict scrutiny, he did put us in a box, and I wish he'd gone with intermediate scrutiny, which is what Brennan and the other liberal justices at the time did. But that box carried us for 45 years and allowed affirmative action for 45 years. But because it's been around for 45 years, that box was no longer going to change and move outside of strict scrutiny. And certainly the conservative justices have been targeting this approach for a long time. And there also are not enough progressive judges, so they have to fight on the other side's turf. strict scrutiny is on the conservative turf, but they've been able to succeed so far. If they had tried to make the intermediate scrutiny argument, the problem is that the majority would have had a field day saying, you say we should follow affirmative action because we have for 45 years. But you're also now telling us we should change the level of scrutiny used during those 45 years? You're asking us to do two completely contradictory things. Which is it? Your opinion makes no sense. So that forced the progressives on the court today to stick with strict scrutiny, because otherwise they look like they're kind of contradicting themselves. But strict scrutiny is the wrong approach, in my view, but it is the law. So.
Does anyone else have any questions? Once again, a couple of people joined after I made this announcement. We did get CLE credit for this program. So if anyone is an attorney, the activity number is 402388.
Is anyone working in this area right now that we obviously heard from one person who's working with the diversity programs. It sounds like it at the university there. The one thing as an academic I always worry about is I'm a little bit out of touch with what's going on the ground. So if anyone wants to share a story or tell me something, but like I said, no obligations, but I wouldn't mind learning from you. So. If not, I think that's pretty much all I've got. Should we wrap up?
I guess so. If no one else has any questions, thank you very much for your time and expertise, and we will say goodbye.
Let me just mention, if anyone wants to email me and seek some information, my email is online. Feel free to email me, and if I can't help you, I can point you to a whole bunch of people here who are working on this issue. So.
All right, great. Thank you.
Sure.
And thank you everyone for coming.